This week's question of the week is as follows. Our 8-year-old son was playing outside and the neighbor's dog came into our yard and bit him on the leg. It hasn't required any plastic surgery yet, but we have had to make several trips to the doctor because of the bite. Our neighbor hasn't done anything but say he's sorry. What can we do about this, if anything? In general, under Tennessee law, if you have been injured at the hands of or the bite of a dog, you may have a claim against the owner of the dog under certain circumstances. In particular, you have to prove negligence on the part of the dog owner as it relates to the dog to be able to recover any money damages from that dog owner. Specifically, to prove negligence on the part of the dog owner, you would have to show that the dog owner was in some way negligent in the handling of his dog. For instance, say the dog owner was walking the dog and he let the dog get away from him, and then the dog caused injury, knocking somebody over or biting somebody else because of that negligent handling. Or you could prove negligence under Tennessee law by establishing that the dog owner knew that his dog had vicious propensities, that he had bitten somebody before or attacked somebody before, and then the dog owner did nothing to properly control the dog, and the dog gets away and bites somebody. That would constitute negligence under Tennessee law, and you could recover for negligence of the dog owner under those circumstances. A second theory of recovery under Tennessee law would be what I call a theory of strict liability. If you can prove that a person owns a dog that is a breed that is known to be inherently vicious or inherently dangerous, you can recover in tort or recover damages from the dog owner for any and all damages caused by that dog. This would require you to have expert witness testimony to testify that the particular dog that caused the injury to your child or to you was of a breed that is inherently dangerous. For instance, some experts testify and believe that a chow is inherently dangerous, or pit bulls, Doberman pinschers, or Rottweilers. But to make a claim against the dog owner, you would basically have to prove either negligence in the handling of the dog by the dog owner. You would have to prove that the dog owner knew that the dog had bitten somebody before but yet failed to control the dog, or you would have to come up with expert witness proof, perhaps a veterinarian who was qualified to testify that a certain breed of dog is inherently vicious and likely to cause injury or harm. If you've been injured as a result of an attack by a dog, I would be happy to meet with you. I'd be happy to discuss the law with you in detail, and I'd be happy to discuss the facts of your case. And as always, I would be happy to help you get your life back after such a tragic event.
Get your life back. Call the law offices of T. Verner Smith for a free consultation. 423-1888. 423-1888.